on David Watkinson's time. So it's maybe 5 minutes less for the coffee break, if that's okay.
Thank you very much, Carol. Thank you for your introduction. I would instruct you to. Thank you for my fellow panel members for their fascinating presentations. Now, according to your handouts, I'm supposed to be talking about running appeals in the higher courts, the European Court of Human Rights. But when I was writing this presentation, it turned out that what I'm actually going to be talking to you about is pretty much just K in the UK. That is why I got the invitation to speak to you, so I hope you won't mind too much. It's going to be a very different sort of presentation from the ones you've just heard. So I'm not going to be talking about law. I'm going to be talking more about what the practice of law means to us and to our clients. Many of us here, I know I'm not talking to everyone, but many of us here came into the law not simply to practice a profession, but actually because we wanted to make a difference, because we wanted to fight for some kind, some version of social justice. And one of the ways in which we do that, we would like to do that, would be by helping campaigns for change in civil society rather than in government. When I'm reflecting on K, I think about some old debates about this, some old debates about whether actually it's a good idea for lawyers to get involved in that sort of thing at all. Because the story of the case starts, for example, of a strong community resistance against what the community saw as repression. Let me take it to the background facts. In the late 1970s, there was a lot of local authority property lying empty, scheduled for redevelopment. At the same time, there was a great deal of homelessness, especially among the young and the single. Spurred by the squatting movement, central government started to encourage local authorities to bring these properties into use as what was known as short-life accommodation. The way it worked was the local authority would give the properties a life, maybe 3 or 5 years before they reckoned the redevelopment would actually take place. They would license the properties for housing associations. Housing associations would access small housing corporation grants to bring them up to a minimum standard, and their properties were in turn licensed to single homeless people in need of housing. In Lambeth, among other housing associations, London Quadrant Housing Association licensed many properties this way. A lot of London Quadrant properties were concentrated in a single road, Rushcroft Road, where there were a load of Victorian mansion houses with purpose-built flats. About half the households involved in the K case lived along that road, including Gavin Kay himself. Then the Conservative government came into power in 1979, and the money to do these local authority redevelopments dried up. And so what was intended to be a temporary measure became an apparent fixture, and the length of people's stay in these properties stretched into decades. And as people began to think of these properties, to treat them as their homes, to decorate them and repair them, bring up families there, some of them, they started to resist the idea that they could be evicted at the drop of a hat, and began to be agitated to be treated as ordinary council tenants. And above Lambeth, in the meantime, was coming to the view that short-life accommodation should be brought to an end and the occupiers evicted, that there was a policy they should receive one offer of alternative accommodation. The street group was known from the mid-1990s as the Rushcroft Road Action Group, or RAG. One of the moving spirits was the Admirable Anna Arnone, who was since qualified as a barrister, practicing from Eastbourne Chambers. They campaigned with vigour. They had their own newsletter, they held benefit concerts and demonstrations, parties, marches and situationist happenings. They involved their councillors and negotiated with council very effectively and formed, all in all, a very vigorous and active community of resistance to Lambeth's plans. Coming to the legal issues for a moment, there was an article Clark from Brixton in the 1980s. It was already clear that there were potential legal battles to come. Surely these flats, exclusively occupied by single households, weren't really licences. Surely Street and Mount meant that they were actually tenants. That particular battle didn't come my way, but was conducted for Gary Bruton, another resident on Rushcroft Road, by James Garvey of GL Hopfield & Co., and in his case, for Bruton and London and the Quadrant, 1996, it was established that indeed the occupiers were all tenants. So, what kind of security of tenure did they have? Lambeth had meanwhile granted 10-year leases to London and the Quadrant, muddying the waters. But in any event, Lambeth dealt with the Bruton case by a simple device of terminating the leases by notice bringing them to an end in August 2000 and bringing squatter proceedings against all the occupiers, most of which had by this time been living in these properties as their homes for 20 years or more. At this point, I want to introduce Gavin Kay and his family. That's their flat. He is actually one of the last of the litigants in this action who is still living in his flat. Lambeth hasn't quite organised what to do with some of these properties in Rushcroft Road. I went to visit him a few days ago, and that's his family. And Gavin Kay himself on the right. Now, Lambeth said that they did offer alternative accommodation for the people who were affected by this action, whether because of the oppositional atmosphere that growed up by this time or for another reason. These offers were in fact very often very half-hearted. What happened in Gavin's case will do as an example, where he was assessed for housing need. He was told that his girlfriend, pregnant at the time, couldn't be counted because she wasn't actually mentioned on the licence agreement. Nothing could have been more impressive than the way that RAG, Community Association, ensured that every single household that was affected by this drastic step, bringing squatter proceedings at much reduced notice periods against these very long established residents, every one of them was reached, advised and brought into the fold, so that in every case where they wished to defend the action was defended, all of them safely stayed while a few lead actions went ahead. There are about 70 households affected. Defending lawyers at this stage included 3 firms of solicitors, my firm, Bindman's, Nicholas & Co, and 3 counsel, David Watkinson for my clients, Nick Toms for Bindman's, and Kelvin Rutledge for Nicholas & Co. I do apologise if I generally give the impression that I was the only lawyer involved. I was, in effect, a community solicitor, acting and advising directly about 40 of the households, whereas the other 2 firms only had 1 or 2 each. I just mean, okay. We had lots of excellent arguments waiting, all aimed at giving the occupiers security as against Lambeth. The best chance, we thought, was arguing that the original licence between Lambeth and London and Quadrant was in fact an agency agreement, so that the licences our occupiers had from London and Quadrant were in reality tenancies directly with Lambeth. There were also some very clever arguments from Kelvin Rutledge around creation and termination of the long leases. As I remember it, there were 10 distinct arguments, and then the Human Rights Act came into force on 1st of October 2000, just before we were ordered to plead our cases, and of course we threw in Article 8 as well. So the case began. It's the largest case I've so far been involved in. The number of clients, in documents, the initial disclosure was 11,000 pages with more to come. Trial of the preliminary issue, excluding the human rights issues, in Central London County Court took a month, and it took place 3 years after the case actually started. In the meantime, what has happened to the occupiers and to RAG? Well, they turned out the court case, they continued to have meetings. What was very apparent to me, and I have observed again and again in other cases, was the stultifying effect of court proceedings on community resistance. Once the court case started, lawyers ruled the roost, and the occupiers felt really helpless bystanders of what the lawyers were doing. More than that, the power and the rituals of the law are mesmerising. They hold everyone's attention, even though the real human issue is almost never addressed in the court. Why should the occupiers care about the precise construction of a 1986 licence agreement between London and Quadrant and that? They care about whether or not they're going to be allowed to stay in their homes. Right. Royal Courts of Justice in the Strand, many of you are very familiar with it. I've always noticed, and I'm sure you have as well, in the grand gingerbread halls the lawyers in their suits and gowns to be seen everywhere confidently striding about and chatting together.